We'll go ahead and get started. Welcome, everyone, and Happy New Year. Thank you for joining us today for our webinar on university patent budget models and effective cost control. I'm Kirsten Leute of Osage University Partners, and I head up our university relations efforts here at OUP. Hush Blackwell is our co-host, and we along with them, decided to pursue this topic on patent models and cost control, considering the budget pressures that many academic institutions are feeling right now. And we've brought in three experts to talk about this topic. We'll go to the next slide. I'm really delighted to be joined by them today. And I'm going to have each of them introduce themselves. I'm going to start with Vinu.
Good morning, everyone. My name is Venu Serene, and I am Associate Director of Patents at the University of Washington. Briefly about myself, I started at a law firm as a patent drafter right out of law school in Minneapolis. Moved to in-house counsel at a company called Digital River. Worked on e-commerce technologies and invention harvesting. Moved to my own law firm to help a lot of garage inventors. Was PTA president, and then in 2021 joined University of Washington as a patent portfolio manager. And then about a year and a half ago, I began in my current role. Thank you.
Thanks, Vinu. Bryce.
Hi, everyone. I'm Bryce Pills. I'm Assistant Vice President for Research, Licensing, and Strategic Alliances at the University of Michigan. We call our office Innovation Partnerships. Just a little bit of background, like Vinu, I'm also a law school graduate. I started my career at Kirkland Ellis and then found my way to the wonderful world of research commercialization, joining the University of Michigan, first in the General Counsel's office, spending some time teaching at the law school, starting their entrepreneurship and venture capital programs. And then about 10 years ago, took my current role leading the licensing alliances teams. Look forward to talking to all of you today.
Great, thanks. And Steve.
Thanks, Kirsten. My name is Steve Gardner. I'm a partner at the law firm Hush Blackwell. My practice is split pretty evenly between IP transactions and drafting and prosecuting patent applications. I started out my career as a patent drafter and then moved out to DC and clerked at the Court of Federal Claims, which is in the news now a lot for all the grant termination challenges. And that's what really got me interested in the intersection of grants and research and IP. And ever since, I have been involved in the tech transfer area in one way or another. And I just want to say thank you very much to Osage for hosting this, and happy to be here.
Thanks so much, Steve. And again, we're really glad that Hush Blackwell has been our partner for this particular webinar. And of course, University of Washington and University of Michigan as well for putting this all together. We're very excited to dive into our subject, but before we do, we'll go to the next slide and we'll just talk about a few logistics as we're going along here. So we are actually recording this webinar. The webinar recording will be sent out to all of the people who have registered for this. It will be available on OUP's partner portal as well as our YouTube channel. The partner portal that I mentioned is an online portal for tech transfer officers and researchers at our partner institutions, and it's full of relevant tech transfer and startup content. Once you're in the portal itself, you do need to register for the portal ahead of time. You'll find a downloadable presentation deck from today, as well as a link to the video for this webinar on the webinars page in that portal. But as we mentioned, it is also publicly available will be publicly available, not yet, on the YouTube channel that we mentioned. You can find these resources via the QR codes that are at the bottom of this page as well if you don't know where they are. I will mention that we do encourage questions throughout this webinar. Please use the Q&A tool in the Zoom bar that's usually at the bottom of your Zoom screen to ask your questions. I'll be moderating those, looking at those and asking them appropriately to our panelists. We do have some other webinars that are coming up. They are noted on here. On February 4th, we are doing a webinar that is in collaboration with certified licensing professionals, and that will be highlights of our popular Startup Licensing 101 webinar series that we gave 4 years ago. We're going to be talking about some of the particular matters that we talked about in startup licensing throughout that webinar series. And then we also have our annual Startup Financing Trends webinar that will occur on March 24th, where we kind of give an overview of what happened in the startup financing world back in 2025, and then particularly look at university startups and financing trends at university startups themselves. So keep an eye out for those coming up Something will be coming to your inboxes soon on each of those to register for those. So we'll go to the next slide. A short intro on OUP for those of you who do not know us. We are a venture capital fund that partners with academic institutions to invest in their startups, typically by exercising participation rights available through their licenses. For those of you who don't know, participation rights are the ability to invest in future rounds of a company on the same terms and conditions as other investors. We do have recommended language for participation rights if your institution is not currently including them in your license agreements. As part of this partnership with academic institutions, they share in our profits and receive programmatic support on tech transfer and academic startups. So we're now on our fourth fund. It's very exciting that we've made it to our fourth fund, and we've made investments in over 150 different companies at this point in all areas of deep sciences, with many of those companies achieving successful exits through IPOs or merger or acquisition. So we'll go to the next slide, just to give you a flavor of the types of companies that we invest in at OUP. We have both a life sciences team as well as a tech investment team. So you can see some of the areas that we've invested in the past. And we're always happy to talk with anyone about our model. If you have an interest to learn more, just feel free to reach out to me. We will be sending this deck out afterwards, and my contact information is in the deck itself. So with that, we will go to the next slide and just quickly show you our agenda. Bryce is going to be talking first about University of Michigan, their patent models and cost models, et cetera. Then we'll go to Vinu at University of Washington, and then finally with Steve at Husch-Blackwell. Please, as I mentioned, do submit your questions through that Q&A tool throughout the webinar. We did receive a few questions ahead of time, but we're happy to answer your questions as we go along here. So with that, I am going to pass the mic over to Bryce.
Thanks, Kirsten. Hi, everyone. We can jump ahead to the next slide. So I'm going to talk quickly about three topics. First, how we make patent decisions at the University of Michigan. Next, how we kind of track and control patent expenses, and then our patent budget model. I like to use the analogy that patent budgets are like gardens. If you're not frequently checking the soil, you're not going to get good vegetables. And if you're not routinely pruning back the growth, it's going to grow out of control. So it takes work, it takes attention. Let's go to the next slide. So when we get a new invention report, we have a team of fellows that will generate a fellows report if requested. Either before or after that, we have a meeting with the inventor to learn more about the invention and the inventor's hopes and dreams for that project. And then we have what we call a WORM, which is a weekly invention review meeting, and I'll talk more about that in a minute. But coming out of that WORM, the licensing manager will then circle back to the inventor and communicate the discussion at the WORM and our plans for supporting that inventor going forward. Next slide. So at the weekly invention review meeting, and we have those every Friday, there's a physical sciences WORM followed by a life sciences WORM. The licensing manager will present out to quickly 3 to 5 minutes, just an overview of the invention, who the inventors are, the external funding sources, any obligations that attach to those, the proposed IP strategy, how we're going to categorize this in our database, any involvement of common collaborators like VA or HHMI, and then the specific plan for supporting the inventor going forward. And these WORMs give us a good chance to have group input on these important topics, in particular compliance, to make sure we've identified the external funding and our obligations going forward, but also the patent strategy, and a chance to have multiple people kind of give input to the decision to pursue patent protection for that invention. Next slide. So when we do decide to pursue patent protection, we have roughly 6 to 8 law firms that we work with that know us extremely well. They know the nuances of university patents. For each invention, the licensing manager will reach out to the patent attorney at one of these firms that they're going to work with and get a not to exceed quote. And we'll do that for provisionals and conversions. Our position is that we are going to vet the invention before making the decision to file a patent application. And so if we're deciding to support that invention with a provisional, we are going to invest in a well-drafted provisional that could be filed as a non-provisional. So having a full claim set, multiple embodiments, and something that we feel will fully support and enable commercially valuable patent claims that we pursue down the road. Next slide. So for ongoing patent decisions like conversions, office actions, national stage filings, continuations, divisionals, annuities, maintenance fees, we're also trying to come up with processes so we can get group input on those. And so for those, we generate a monthly report of all upcoming patent decisions for unlicensed patents. And at the first worm of each month, we will, as a group, go through that report. And so it typically has 75 to 100 upcoming actions. And it only takes about 15 minutes to go through at the end of the worm. And for each action, the licensing manager will go through what they're intending to do and very quickly why. And for certain things like national stage filings for an unlicensed patent, we'll pay close attention to that and make sure we believe enough in that patent to make that level of investment. Next slide. So for costs, at least once a quarter, we get a report out from our finance team on our patent costs for the year so far, our reimbursements, and the projected total patent spend, both total and unreimbursed. You can kind of break down the patent budget into two components, the total spend and then the unreimbursed spend, which is what we pay close attention to because that's coming out of our pocket. And when we get that number, we will, take a close look at the details. And so you can kind of categorize that unreimbursed patent spend a couple different ways. One is what are generating those unreimbursed patent costs. And for us, it's typically 80%, truly unlicensed patents. And so a patent that we believe in that's not licensed yet that we hope will be licensed. 20% are patents that are licensed where the licensee is not paying us for some reason. 6% of those are because we decided to defer patent costs, and then 14% are where they should be paying, but they aren't. And for that, we have processes in place where we can appropriately handle that, trying to balance the flexibility that startups need with trying to make sure that licensees are, complying with their obligations to fund the patents they're licensed. And so each month we get a report of accounts receivable. We have a team and our ops team that's spending significant amounts of time tracking that, making sure we're seeing what payments are due, and then communicating with the licensing manager about what's the appropriate way to handle that cost, whether we're going to extend flexibility and wait, or whether we need to have a conversation with the licensee. Next slide. Another way to break down those unreimbursed patent costs is what's the patent activity that's generating the cost. Frequently people's first reaction when they want to try to cut back or control unreimbursed patent spend is, look at the new filings and maybe let's file less or decrease that cost per filing. And for us, at least 80% of our unreimbursed patent costs is with ongoing prosecution. So a pretty small chunk of it is the new filings. It's mostly, filings that have made in the past that are still going through prosecution. Next slide. So when we think about kind of controlling our patent spend or maybe even slowing it or trying to reduce it, we see 5 tools in the toolbox. And I'd love to hear from our co-panelists on like how they think about these and whether there's other tools we should be thinking about. But the first two, relate to the new patent filings. So either reducing the cost per filing or reducing the number of filings. And those are important things to do where we have ongoing processes to check those and make sure we're making responsible decisions. But those tend to have a relatively low impact because new filings are a pretty small chunk of our overall unreimbursed patent spend. Where we do see a significant impact is on ongoing prosecution, in particular portfolios that have built up for a particular inventor. And what commonly happens is you have a prolific inventor that reports an invention and we file on it. 24 months later, there's another invention related to it and we file on that. 2 years later, there's another invention, and pretty quickly you've built up a big portfolio. And those may have all been wise and prudent decisions. But what that presents is an opportunity to sit down with the inventor and say, all right, we have this portfolio, we still believe in this, we think we're going to be able to license this. But with the benefit of hindsight, which of these applications do we want to prioritize? Which of them really need foreign protection? Which of those can we cut back on to preserve dry powder because we want to be able to file on your next invention? And that's something where inventors will readily cooperate with. And, we see a significant impact in terms of being able to, cut back on that ongoing patent spend by pruning that growth. The other thing you can do is try to increase the number of licensees you have that are reimbursing patent costs. I mean, the best patent budget in the world is one where you have a large percentage of those costs being reimbursed by, qualified licensees. And so, we invest heavily in processes to actively market innovations to existing companies who will be able to reimburse for patent costs. And then, like a lot of the schools on this call, a large percentage of our exclusive patent licenses go to newly formed startups. And so we've invested significantly through our ventures team and otherwise in programs to increase the number of high quality investable startups that we launch that are able to, cover the patent costs that they've licensed. And then the last thing, as I mentioned, is investing in the people and processes to monitor reimbursements from licensees. And it takes a significant amount of a few key members of our ops team to monitor accounts receivable and then have the communications with licensing managers as to how to handle those amounts that are due. Next slide. I'll just quickly give an overview of our patent budget. Every university has a different way of funding their patent activity. At the University of Michigan, it is solely funded from our revenues. Our office's choice would be to have this, centrally funded, and, get, the amount, needed to fund a large patent budget supplied by central administration. That's not the way our university has chosen to do it. So given that environment, what we do is as revenue comes in, we first reimburse any unreimbursed costs for inventions that are in that license. We next will take a 7% administrative fee to fund our patent budget. We will then distribute to the inventors. And so at the University of Michigan, that's 50% of revenue up to a certain threshold, and then it drops to 30%. But then before we distribute to the non-inventor stakeholders, central administration, schools and colleges and departments, we will recover any yet unreimbursed patent costs for the year. And so in order to do that, we have a percentage based upon our projections, that we're anticipating we need to recover in order to cover that cost. And the theory being is that, we'll share profits with those internal non-inventor stakeholders, but we're first going to, cover the expenses that were incurred in patents in order to generate those profits in the first place. So that's all I have to share. I look forward to hearing from my co-panelists now.
And I'm going to ask you three questions before we move on to Vinu. I'm going to hold off on a couple of the questions because they apply to Vinu's talk as well. But Bryce, do you ever file cover sheet provisionals if the commercial landscape is not strong or promising?
We won't do it for those reasons. We will meet a publication deadline, so it does come up from time to time where an inventor says, here's an invention, sorry, I'm presenting at a conference tomorrow. And there, obviously we don't have the time to draft a full, non-provisional type application. And so we'll do the best we can. But we will not rely upon that as being an enabling patent application that will definitely give us our filing date. What we will do is then follow up as quickly as possible with a fully drafted provisional.
Great, thanks. Next question. How often does a licensing manager go into a worm intending to file and get talked out of it or reverse during the worm? Does it happen pretty often or not?
It doesn't happen a ton, I'd say, because of our amazing licensing managers that are already making great decisions. But there are times, where someone will point out, something that someone wasn't aware of, or more commonly, some commercialization consideration. Are you aware of like these change in regulations that are going to make the regulatory pathway much harder than we anticipated? And so there are often times where there's kind of group discussion that impacts the level of support we provide going forward. But typically, we've done a pretty robust prior art search coming into it. And so that kind of patentability assessment tends to be pretty solid.
Great. And last question for right now. There are a lot of fantastic questions coming in, but we're going to hold off on the other ones because they're going to be relevant for Vinu and Steve as well. Please elaborate on how the not to exceed budget for a new application is set by the licensing manager.
Right. Well, normally it's a question to the patent attorney, where we say, hey, can you give us the not to exceed quote? And the patent attorney, after reviewing the invention report, the fellows report, and sometimes having a conversation with the inventor just to get an understanding of the amount of work that's going to go into drafting a well-drafted provisional, will come back with that quote. And we have a sense of where that quote should be, based upon a lot of past history. But it is proposed by the patent firm. And then if we have a concern about it, then we'll have a discussion.
Great.
And I will just jump in as being the outside counsel. It's not always complexity of a technology that drives our quotes. It will be what is the shape of the materials? If there's a full academic manuscript with all the data and tables put together already that we can directly convert versus back of a napkin type of invention. So it's not always what you think. And I think that's a place where tech transfer could probably work with your counsel to eke down those budgets by some prep.
Great. Yeah, it's a really good point, Steve. Thank you. All right, we'll move on to the next slide and to Vinu.
Good morning, everyone. Thank you. My name is Venu Serene, and I'm at Commotion at the University of Washington. Next slide, please. And just some facts about our university. Everything is on our website, so I'm going to flip through these slides pretty quickly. Next slide, please. So this is, if you know Seattle, we're located at the University of Washington in Seattle, and we have 3 different locations. Okay, we're back to this slide. And next slide, please. So I just want to mention our locations again. We have 2 startup locations, startup halls, and and our headquarters is a brutalistic style building. And the reason I'm mentioning this is even though our headquarters is brutalistic, our IP management is not. We are very elegant IP management. So next slide, please. And then all of this, we have various internet connected services. All of this is on our website for anybody curious, can look at that. And next slide, please. And this is our in-house team. There's me, and we have a trademark and copyright manager. We have 3 patent portfolio managers. These are registered patent attorneys, so they can do in-house filings. We have a patent specialist who works on some of our patent searches in-house, and that was one way of reducing spend for us instead of using outside vendors. And then we have 2 paralegals, and then of course our trustworthy outside counsel, and we work with 13 different firms. So next slide, please. So similar to what Bryce was talking about at the University of Michigan with the weekly worms, I love that word. We have a weekly intellectual property forum. And this, I call it kind of like a train station. There's always trains. And we have this every Wednesday at 1 p.m. And if you miss 1 week, you can get on the next week's intellectual property forum to get things filed. It provides rhythm and discipline, that we can make decisions quickly, keep filings on schedule, and avoid rush fees. And this is where we go through patent strategy, similar to how Bryce was mentioning funding obligations, patentability. It's just an early triage form. Provisionals is where we buy time for diligence, convert, when there's different kinds of provisionals. I won't go into detail there, but anywhere from how Steve mentioned the paper napkin provisionals to a fully enabled provisional, depending on what the needs are for that particular situation. Conversion to non-provisional or PCT only happens when the case shows real potential. And this is a constant conversation between our innovation managers, which are basically licensing associates, and then our patent managers or the patent attorneys. And they'll up to intellectual property forum, there would have already been discussions going on of all the different factors that go into these discussions. And oftentimes we will also have what I call pre-IP forum meetings. We've actually started that more robustly this past few months, where we will get on a call with inventors early before IP forum to really flesh things out and see if there is real potential for something. For national stage filings, this is, of course, as everybody knows, this is when expenses multiply. So we treat this for us, for University of Washington, as a hard gate, meaning that we do not file broadly internationally, just in case. We just don't have the budget for it. At national stage, foreign filings are conditional on a license for us, and we only pay for national stage abroad when a license or funding partner is secured. And this just reduces speculative spend overall. And I think there was one question I saw briefly that, do you ever say no? And that does happen during IP forum, but it's not a blanket no. It's usually a let's put a pin in this and come back to it because we have a set of factors that we use for our decisions. It's like a 2-page document that we have, and if some of those factors are missing and not met, then it means we really need to come back to this. So our no is usually a soft no. It's rarely a hard no. And then we do have fee cap. We have a whole fee cap document. And by the way, if anybody wants to, on this call, any other universities, if you want to get on a call with me outside of this seminar, email me because I know I'm not going to run through exactly what our fee caps are. But if you want to run through those with me, I can show you on an individual meeting. But these fee caps, they have different tiers with our firms. So this way we get predictable costs and consistent quality. This makes our portfolio just more forecastable, and then we can reallocate funds to highest value cases. And it's just like, Steve was saying, there's certain materials we might get from an inventor. I think yesterday for our IP forum, we had a new invention disclosure that had 112 pages in a manuscript. So that is going to be tier 3. And right away, I don't even have to think about it. It's going to be tier 3. Yeah, that's a little different than what Bryce was talking about, the not to exceed quotes, because we have just these sort of blanket fee caps in our process. Next slide, please. Thank you. And then just going back to more about this intellectual property forum. These innovation managers work closely with the patent managers, and this is just a governance model for us. And selecting outside counsel is also a big part of our intellectual property forum. Again, I said we have 13 different firms, and we actually have a document that outlines every firm's technical expertise. And we have relationships built over time, so we kind of know which attorneys and which firms to go to for what. I want to talk about something called continued prosecution forum. So this is a segment of our intellectual property forum where patent managers present continued prosecution requests. What does this mean? This means it's not new patent filings. It's after application has gone into prosecution or examination. So this is our licensing managers are not necessarily involved in this. This is where now we've gotten office actions, restriction requirements, requests for increase in budget. Maybe counsel is asking us for more budget for some reason. And this is where our patent managers will bring it to the second half of intellectual property forum and request for more funds. And it's another presentation, and it's very detailed, and it keeps costs from going out of hand. And our paralegals take detailed notes and enter into a database so that 3 months from now, when we get an invoice from a law firm, we can match our records to what the law firm is charging. Yeah, that's it for that. Next slide, please. And then just briefly going over our licensing revenue model. And as Bryce was explained so well, every university has a different system. I'm going to just start at the box that says gross licensing revenue pool. What we do is first we, when we collect this pool from different licenses, first we fulfill the team right away. So if the inventor team had different not inventor team, licensee team had different costs, for example, growing things in the lab, creating software, we'll fulfill that first. Then our patent cost recovery, of course, we make ourselves whole. There is a 20% admin fee. And then after that, whatever is left over is distributed, as you can see in those boxes, inventors, department school, and provost research. And I do want to talk briefly about our legal billing and how that works, because I think it's different for everyone. It's a pass-through system, meaning the firms bill us and then we bill the licensee. That's just the way that works for us. And also with our, for the past due amounts that I think Bryce was talking about briefly, we have something called a prepayment process that we created in 2017. And basically, there's sometimes, small startups, licensees, sometimes they can't make their, costs. They are behind in payments, and that's just the reality of the world. And in those situations, we mark them in our system as, they're under prepayment, and we have to work closely with our finance team. And what we do is any action in the patent prosecution has to be first paid via prepayment invoice. Then we will proceed forward. It's a little cumbersome because I don't like that. It's a little slower than just moving forward with things, but that keeps our costs way down in those particular situations. Next slide, please. Uh, and then just briefly, this is our how our spec budget and reimbursable budget is broken down. Our spec budget is roughly 30% of our overall patent budget. Next slide, please. So, and these are just my personal tips. I've been working on a patent budget now for a year and a half, and I've learned a lot. So, going back to IP Forum, such as Bryce's worm at University of Michigan, it looks like every university has some kind of forum or meeting that they do every week to discuss this. Some kind of mechanism like that, I think, is really key. We do fee cap tables and detailed caps, again, for every action with sub-tiers. We also have detailed client notes. So as a client, we actually have a 12-page document that I just updated this year that we send to all of our law firms for how to work with us. We have a large volume of, patents at various stages, and it has special instructions to how to align with our priorities. And this way, we're not constantly telling law firms what to do. We have any paralegal, any lawyer in any law firm can just open our document and be like, okay, how do we report this? How do they want this reported? What email do we send this to? Because we have different email boxes for every kind of situation. We have, down to even what the subject line should say, and how to put matter numbers into the subject line. I just think it keeps everything really organized, and overall will reduce costs and confusion. Our in-house team, I think, keeps costs down because we're all, as I said, have reg numbers. We can file in a pinch if we need to. Relationship with outside counsel is really important. They are our partners, and we rely on their expertise. I do oftentimes law firms will want to meet their clients, right? They do, they'll come out to visit you, and I try to bring them to our building, our brutalist building, and I'll have a meeting on site. And I think this develops a really great relationship with our law firms when we meet our team. And when they're meeting us, I will often ask them to provide a presentation if they have something in their back pocket. Oftentimes, law firms will have a CLE they're going to present anyways at somewhere, or they're formulating ideas for a CLE. It just provides just learning for everyone in those situations, and creates a good relationship. Communication with counsel. I think it's really important to respect your outside counsel's time and be very frank with them in situations. So if you have a situation where you're like, wow, I think costs may go up because this inventor group, they're out of town. Maybe there's a flaky inventor, maybe there's a inventor who is, not behaving the way you want to behave. Those are rare situations, but maybe there's something complicated there, or you think an inventor needs a lot of extra help. And then I will get on a call with counsel, and I will be very frank. I've said, I don't have the budget for this, but this is what I want. Can we make it happen? And I can tell you 99% of the time it's a yes. We just need to communicate. We just need to bring everybody to the same page. It's better than just like surprises, right? And then so that just keeps the relationship good overall. And then finally, giving yourself grace, as I've learned in my first year working on a patent budget. At the end of the day, it's all disclosure numbers, and federal funding can change things, as we know. Thank you very much.
Great. Thank you, Vino. A few questions for you. Is any IP budget received by the office from the university?
Yes. Okay. Yes. So, yeah.
Just yeah. Anything else you want to elaborate on that?
I'm not going to elaborate because I don't want to say the wrong thing. Yeah.
Okay, great. And then next question was, what percent of potential partners have bargained terms of a license down or walked away because of no pending foreign patent rights? And I'm actually not sure if you would know that since you're not on the licensing team.
Yeah, I'm not in the licensing team, but I think that does happen when if there's no foreign. If I'm assuming the question is asking if we have not filed
If you
international.
haven't, right, if there are no pending applications or, issue patents for foreign filings, has that caused any issues? But yeah, I think that's more of a licensing question.
Yeah,
So you
and that's
kind
a
of,
negotiation over time. And there have been situations where I think because there's certain countries, there's a 31 month mark
yeah.
time period. So it's like a month after our national stage. We
Yeah.
will there have been unique situations where we will just file that. We put a patent management agreement in place. There's something there to recover costs and help with that. If we think that license, if we are like so sure that license is going to be signed, I mean, we really, really need a lot of assurances, and we will go that way, and maybe perhaps pay for one or two countries, or other jurisdictions. But I would imagine it does happen when, I don't have that personal experience, but I would imagine it does happen where a licensee would need to walk away if they haven't met all those jurisdictions.
Okay. And last question, because we need to get to Steve, but and we have so many questions to get to, but this is particularly about your continued prosecution forum. So this person asked, prior to the continued prosecution forum, has the IP manager already discussed with the business manager to understand that the case should be continued? This person thinks yes, but wasn't clarified. So they just wanted clarification on that. Have they already talked about this ahead of the IP forum?
That's a great question. Yes, the answer is yes. So
Perfect.
yes, our patent managers will check with the innovation managers whether a certain case should be moved forward. So that's usually via email, in person, in the office. They will have these are ongoing discussions. So they usually have a
Yeah.
good idea before it comes to our IP forum or CP forum.
Great. Thanks. Well, we have lots of other questions to get to, but I want to make sure we get to Steve. So we'll move on to Steve's slides. Next slide.
Okay, thanks, Kirsten. My my goal with this was to start digging into, some granularity on what actually it makes the patent prosecution process expensive. As law firms, we have a lot of data on this, actually. There's public data, but then also down to the tenth of an hour, exactly how much time do we spend on everything and why do some things cost more than others? So if we go to the next slide. I broke down the patent life cycle in its entirety into some phases here, and this really completely independently of what Bryce and Venu said. I think we all came to the same conclusion that so much of the cost happens after filing that it really makes sense to look there first. And so my assumption here was there's already an application filing, or you've decided to file it, and then an office might have had some budget cuts or something like that. And so I think there's some clear areas that you might want to consider cutting first before deciding to file fewer cases or apply a more rigorous criteria to decide whether to file or not. Um, the initial application drafting tends to be the most expensive individual line item. And early on last spring, when grant terminations started happening and there were some budget cuts to various institutions, um, there were a lot of ideas floating around about what to do, and some of it was, renegotiate rates and cut costs across the board. And I think maybe a more tailored approach makes sense. What I have generally been seeing is, um, whether your application drafting fee is another $1,000 or $2,000 tends to be washed out almost completely by everything that happens later. But skimping on the initial application drafting can actually make everything else more expensive. I know there were a couple questions about cover sheet provisionals and that sort of thing. This actually came up at Autumn West last year. Was one of the more heated discussions, surprisingly, was how to tell outside counsel to do something on the cheap or just a medium quality. Um, our malpractice carriers don't have a medium anything. We should just do an A+ job all the time. And I imagine everyone's outside counsel thinks that way as well. So I think if there's circumstances where you're looking for something that's like tiered in value or maybe something slightly more than a cover sheet provisional, to Venu's point, having good communication with your outside counsel is really important because knowing what a client means by medium quality is not great. But I think if you just ask your outside counsel, this is what we want to spend, what would you recommend we start with? I think all of us will know here are the important things for this type of technology. In contrast, I've got a few items here that are highlighted, everything basically between the initial application drafting and the allowance. Those are the ones I would cut first. Um, and so I've thought about this in terms of both their cost, the risks associated with it, and the value. And that last one comes from my colleagues and I, in addition to working with universities and early stage technologies, we also do IP due diligence for later stage acquisitions. And I can tell you confidently, I've never told a client you should pay more for this asset because they had an awesome declaration from their inventor signed at a certain time, and not even an IDS. There's really very few of these things that actually come up when people are really truly trying to evaluate a technology for an exit. The one exception might be substantive examination. I'll get to that later. It really only comes up in IP due diligence in a negative way. And so less is more there. So while there is some risk and cost, there's really no benefit. So if we go to the next slide, we can start talking about how these things come out in practice. So I looked at some public data. There's a variety of patent management tools and data resources I'm sure everyone can get to. Some are free, some are paid. But it really confirms that I would say over 70% of total cost occurs after initial application filing, and that's true both from my own data, my colleagues here at Hush, as well as just looking at university patent life cycles in public data. But the things that happen surprisingly often are a lot of these things that don't add a lot of value. For example, restriction requirements, it will never come up in IP diligence. I don't know that VCs care whether you filed a really good restriction requirement or not, or whether you even filed one at all. In looking at a random sampling of some R1 institutions, the occurrence rate of restrictions varies tremendously, from about a third to over half the time. So if you think half of your applications you're paying outside counsel to file responses to restriction requirements, that can add up. And it is an avoidable thing. Again, if you have conversations with your outside counsel and say, hey, we don't want to spend on this, they can tailor claims to be more likely to avoid restriction requirements. There's also a lot of notices to correct in this industry, all sorts of various formalities, and just the churn of patent prosecution. And I think one cause of that is a lot of these patent applications are being written based on content that the inventors developed for like a poster or an academic paper, and it just doesn't translate really well to a patent application. So again, I think having some conversations with your outside counsel about where to apply cost is a good idea. Most outside vendors who do patent drafting will convert, say a multicolored drawing that an inventor came up with into a black and white line drawing for less than $100. And so again, you could cut corners on the initial filing, but then how often do you get these follow-on things where tables and figures and drawings and equations have to be corrected? It seems pretty clear to me that the, slightly more cost upfront will save you later on. Then the other thing that happens with fundamental technologies, like come from university research, is a lot of these difficult and repetitive rejections. This was pretty interesting to me. When we look at our industry clients, they have fewer average numbers of office actions per case. And I think that's the median number is a little different, but it's driven a lot by there's a whole chunk of applications where they know they are not trying to claim the whole world and they know what exactly their product looks like, and it's either protecting a specific product or it's defensive. And so I think they do a pretty good job of communicating with outside counsel in regard to what it is they're looking for. But again, looking at the same sampling of our one institutions, there's a range of 1.3 to 2.5 office actions on average, which means you probably are spending $7,000 more than your peers if you're on the higher end of this for every application you file. The reason for that is hard to glean from public data, but it's a big difference. Another factor is just average pendency, how long it takes to get to issuance. And I'll touch on that a little bit more later on, but that's a big swing. 18 months is probably three more office actions, which adds up. It's probably $15,000 on average that those institutions pay for their applications than others. And then a 50% to 80% allowance rate, which is obviously a very big swing. Um, I think there are two reasons why there's such a difference there. There are some institutions that do a really good job of culling cases, and so they just never issue. And then there are some who do a really good job of, instead of just abandoning a case, just deciding to take whatever allowable matter there is and get it over with. So there could be a lot of reasons why allowance rates are what they are, but I think it's a good statistic to look at nonetheless for your office. But looking at all of these things, my conclusion from looking at all this public data was there's differences in approach at each tech transfer office once an application has been filed, and I think that's driving a lot of the cost because there's some fairly significant differences between what I would guess are the spend per application across institutions. If we go to the next slide. So then I looked at our own internal data. We know exactly, like I said, to the 10th of the billable hour, what is expensive and what is not. And this has held true. I've worked at four law firms and had lots of different colleagues and called some of my colleagues, former colleagues, and it's really true. Total pendency of a matter from the day you engage outside counsel to the day that it issues is the number one driver of cost. And that's even an independent variable from the number of office action responses. Just things happen that cost money the longer a patent application is pending. So the faster you can get to an allowance and resolve it, the less expensive it will be. It's fairly easy to understand. Um, Again, a lot of responding to just sort of churn of patent prosecution, notices, restrictions, those sorts of things. There could be reasons why certain tech transfer offices, have to file their cases faster or, um, different reasons why they're filed the way they are. But that tends to drive cost. Then office actions, and it's not singling anyone out. This my firm does this just as much as anyone else. You get to the point where you see an office action response one after another on the same issue, and more rejections, more RCEs, more responses, et cetera. That creates cost. Some of these online tools for patent management will actually tell you the rate at which each office action you file decreases the number of remaining rejections. So how close are you getting per spend? Which I think is a great thing to look at. But to Vinu's point, that really gets to just telling outside counsel what your goals are. Do you really want to fight for the broadest claims possible? This is licensed. It makes sense to have a lot of office action responses. One of the biggest write-offs for outside counsel is actually IDS filings, which generate really no value. There are some of our clients who do that on a fixed fee, some who do it hourly. For our industry clients, they'll send us a disclosure and say that there are three patents that are prior art. File these, and it's our paralegals do it in less than $500. And that is not the case for academic innovation. As you all know, there's just a lot of references being cited. I have seen $4,000, $7,000 being incurred, and a lot of that winds up getting written off because it's just churn. A few other things are just how difficult it can be to contact inventors and other things that happen, the reporting and the communication and churn. So next slide. So what this boils down to, looking at my own data and public data, you should spend less money on things that don't add value, don't have risk, but are expensive. And that list is quite clear. It's most of the things that happen after you file your application and before it gets allowed. So next slide. So then I looked at, okay, what are the risks? What if you were to skimp on some of these things that happen or instruct your outside counsel, we're okay with you doing, less than the 100% best job possible. Declarations and assignments can sometimes, if you don't have those as part of a fixed fee, they can sometimes be those things that add up, just communications and tracking people down. Looking into the case law on this, there's almost no chance that anything would go wrong if you had your inventors sign the declarations before the application was filed. Same thing with assignments. So talk to your outside counsel about this, but If you are seeing a lot of invoices where there's a sort of a churn of trying to get formal documents dealt with, I think you're reasonably in the clear if you just take care of that very early on and don't worry about having to hunt down grad students later on. Same thing with IDS filings. Almost no courts nowadays are actually invalidating patents because you didn't submit a reference to the patent office. There really has to be like a smoking gun email, the last case I think that actually invalidated a patent because someone didn't submit a prior art reference here in the US was the CEO had emailed their internal patent manager and said, "Don't send this prior art to outside counsel or we won't get a patent." And that came up in discovery and litigation. So again, you can talk to your outside counsel about this. Some offices have resources where you're using the university library to pull copies of references, and maybe it's the easiest just to have your interns pull copies of everything. Maybe it's easier to have your outside counsel suggest or your inventor suggest a culled list of references, but I think in those circumstances where you're finding yourself with really big bills for IDSs, you could probably find a lot of ways to trim there. Next slide. These pre-examination activities, I would say this is one of the places I've been really happy with AI tools actually creating cost savings. Um, we get vendors like crazy marketing tools to us that will write the patent application for us, and they don't really work all that well. I've not noticed a tremendous difference in invoices. Our team can blow a fixed fee budget whether we're using those or not, but in terms of quality control, they're actually very good. And they can save you on some of these notices. So I think if you talk to your counsel, which tools do you have? Can you make sure that you're using those? It really helps. One of the things here at Hush, just to be candid, that I sometimes struggle with, and this has been across law firms too. There's a lot of tools, but sometimes people are busy and it's not part of their best practice to use them. And so AI is not going to cut cost unless it's actually being used. And so if that's part of your outside counsel guidelines or that's part of the conversation you have with your outside counsel, look at how much more would it take you to run this? Do we need to add, another half an hour of time onto a budget so that we can make sure these get run? Because it will save down the road. They'll check for all kinds of errors in your application. So again, talk to your outside counsel about tools for quality control. And then finally, just to reiterate what Bryce and Venu said, telling your outside counsel your goals once substantive prosecution starts is so tremendously important. You'd be surprised how often we don't know what you all think of the value of a given technology or whether it's still valuable. I mean, we might have had a note at one point in time that there was license interest, but a year could go by before we actually have to respond to an office action. So having communication about what you want is really important to us. Sometimes that can be an outside counsel guideline. Sometimes it can be on a case-by-case basis. But if you tell us your goals, not only will you get, I think, a less expensive overall prosecution, but a better patent application. Because the more we fight and make the smallest amendment possible, the more amendments there are, the more expensive it gets, and the more estoppel and prosecution history and sort of black marks there are on your applications. Next slide. So this gets to one of the questions I saw in the chat earlier on. How do you predict and budget cost once you've filed an application? And there are some good ways to do this. Um, I think if you have some of your own portfolio management tools or your firms might have one, we use a LexisNexis product called Patent Advisor, which is where I found a lot of these statistics. But I think the important thing is to every year look at cases that are going to be expensive, not how many office actions do we have right now, because your counsel's probably already incurred cost. But what will have prosecution activity in the next year? So look at all your cases that are either in active examination, have been assigned to an examiner, or are about to be. And the USPTO has a pendency dashboard. Right now, on average, they are up to almost 23 months between when you file an application and you get your first office action. 2 years ago, it was more like 16 months. So, but you can look at that. You can find that statistic for your own cases. You can find it by art unit. But it is possible to know in advance what's going to be expensive. And we found when we have clients that look at these things, they can tell us this technology has never been marketed. Just cut it. Or don't abandon this case, but file a preliminary amendment and narrow down the claims to one claim set. So we're not going to get restrictions or a lot of office actions. Lots of times the inventors have left, their startup went under. That's helpful information to tell us before we start making recommendations for you. As far as foreign prosecution costs, there's plenty of services that will do that. We use global IP, but there are other prediction tools. And I've got a little snippet here on the slide, which you can look at later. But if you made direct filings in 4 countries, it calculates out the filing fees. It guesses what a foreign associate fee would be and the total annuities, and it'll tell you what the fee is. I think foreign associates tend to be in a position of having even less insight into the importance of a case than even your domestic counsel. So if you tell them, what can we do to get to allowance fastest? Or all we want are the same claims we got in the US. That's tremendously helpful towards cutting cost. Unfortunately, with foreign prosecution, just the annuities and fees are going to be the biggest chunk of it. But even with some of those, you can sometimes defer prosecution in some countries in order to wait and see how things go in the US. So there definitely are strategies for predicting and limiting foreign cost as well. Next slide. So I'll just wrap up with a summary in case I haven't said it enough times already. I think the best way to implement a budget cut, don't cut corners on application drafting, and hopefully don't file fewer applications if there's good candidates just because of budget. It really is a partnership between your outside counsel and your office. We want you to have more filings and want you to be successful because when the tech transfer clients are successful, so are we. So I think you really shoot yourself in the foot if you are not being explicit about what you want in your patent applications or cutting corners. I think the much better place to limit cost is everything that happens after a patent application is filed, and that just takes communication with your outside counsel.
Great. Thank you so much, Steve. We're going to take down the slides for the moment. Steve, I have a few questions for you. We had a lot of questions about IDS coming in. So people want more clarification on the IDS part. So I'm going to ask a few of those, and then we'll get on to some of the other questions. For those of you who do need to leave at the top of the hour, we are going till 15 minutes after the hour, but for those of you who do need to leave at the top of the hour, we do have a survey, so please do answer our survey. It's 5 questions, super fast. So please let us know what you thought of the webinar, but also suggestions for future webinars. We're doing our webinar planning for this year right now and have some really great ones coming up. So anyways, going back to that, Steve, to these questions. So this question is, the USPTO is now charging for IDSs over 50 references. How do you recommend trimming your IDS list to under 50 for budget reasons? But most universities submit all references from a journal article and don't have the time to pick which ones are relevant. Question, and any thoughts on that?
Yeah. I'll tell you, there's some clients of ours that we've agreed on this ahead of time, so I'll tell you how I do it, but there are some other ways to do it as well. So I take the inventor's manuscript and I run it through a language model. We have some that are hosted here internally on the firm's own servers. And we developed a prompt that just said, based on what these references are cited for in the context of how they're being cited, predict what you think the inventors thought were the most relevant references. We don't try and, in the abstract, determine whether the references are or are not more or less relevant, because that's not the standard. The standard is what was the knowledge of the inventors. So we take that list, and it's usually a third, and then we'll send it to the inventors and say, this is the list that it seems like you thought was relevant. Do you agree? And we tend to get a lot more of a response to that than we do trying to actually go through and figure out what was relevant. And then we hedge a little bit. I think if you have your LLM rank references instead of just picking the most relevant ones, it does actually a lot better job of that. But for others who are more cost conscious about IDSs, they'll just ask the inventors, this is the standard. What do you think is relevant? And save that email because it shows that you weren't intending to deceive the patent office.
Okay. And then there's an opposite question, which is when you're doing due diligence, does a skimpy list of references or not enough reference in IDS reduce the value of a patent? And you kind of already had answered this, but I wanted
Yeah.
to, because someone specifically asked it,
Yeah.
I wanted to ask. Okay.
I've never had, when we're representing the acquirer, I've never had them ask that. They don't even care what's in the IDS. They want us to scorch the earth and find all of the prior art, regardless of whether it was ever in an IDS or not. It's so much more of a risk that patent will get invalidated based on prior art than based on some sort of like inequitable conduct or, intent to deceive the patent office ground that almost none of them ask us to even look at the IDS.
All right, we're going to move on to foreign filing. There were a lot of questions that came in about foreign filings, and I think I'm going to summarize it with the question that someone else asked was, what are your recommendations on controlling for foreign associate costs or foreign filing and foreign associate costs? So, and I'm going to ask each of you this because I think you might each have different answers, and it may answer a bunch of the other questions on foreign filing. So, Steve, I'll start with you.
Yeah, I think, like I said before, just making sure that your licensees understand all the fees. Sometimes they get really surprised by that.
Mhm.
So, lifetime annuities are really easy to calculate. And that can help with too many cases going unreimbursed. But then talking to foreign counsel, and if we can give them copies of what we filed in the US, the entire argument, have that be reused, and just being really clear to them about the scope of what it is that you're asking them to do and your goals. Um, the variability in their cost is going to be really similar to ours here in the US. You just don't know what a patent examiner is going to do. But, asking them early on, what can we do to avoid cost? They're very happy to tell you.
Okay. Bryce, same question to you, and also just about, making the filing decisions initially.
Right. So we will make national stage filings if a patent's unlicensed. We obviously try to avoid it. But we kind of look at it by different technology type. I mean, therapeutics, we very commonly will file at least in Europe. If not a few other jurisdictions, if it's unlicensed, but we believe in the project and think that we're going to find a licensee, or especially for a therapeutic, more commonly an entrepreneur to just spin out a startup. It's less common outside of therapeutics, although med device, which we kind of break down into like therapeutic type med device versus widget type med device, and so therapeutic type med device. We're going to treat more like a therapeutic. And even though we haven't found a licensee, if we believe in the project and believe we will, foreign protection is going to be important. And then in physical science is less common, although there are areas like semiconductor batteries where in particular, like protection in the Asian countries may be important or may even be critical to finding a licensee. So we're going to closely scrutinize it, but we will do it if we believe in the technology.
Thanks. Vina.
Yeah, for foreign associates costs, I think that was the original question, right? For that, we're not going to be working with them anyways. It's going to be through our law firms. And for licensees who have questions, like Steve was saying, that they have always surprised by foreign associate costs, and they will sometimes, ask us. And what we do is we give a range. And again, that usually a big range because it also depends on strategy at the moment. You can't just say, oh yeah, this is going to be this office action or whatever in India or China is going to be 3,000. It could be 3,000 to 8,000, and it depends on so many factors. So we just give a range of cost, like maybe 3 to 8K, and it's up to them at the end of the day.
Great. We have a couple of questions now about filing. When one, maybe your team decides not to pursue something, but the faculty or researcher would like to thinks it should be pursued. And then another question is like if you don't have a licensee, but it would like to be pursued. So let's start with the first case where your team has gone through the worm or the forum, and have decided not to file on it. How do you communicate, and what happens then with you're not either continuing to pursue or pursuing it in the first place? What happens to those particular technologies? Bryce, let's start with you.
Sure. Well, the first thing is like we lean in heavily to trying to provide phenomenal customer service to our inventors. And so we try to reframe that initial, invention assessment away from like a thumbs up, thumbs down, and more into how can we help you? And so let's just say there's a case, inventor thinks it's the greatest thing in the world. We don't think it's patentable because we found prior art, or it's a target and we think there's like 112 or 101 problems. And so we will go back, and say, hey, like, we don't think, based upon where you're at right now, we can get a commercially valuable patent. But here's some steps, here's some resources, to get to the point. Here's a research collaborator, to get to the point where we would be able to file something. And so we really try to avoid, something being framed as like inventor believes in it and we're saying no. And if there is a situation where an inventor, we're just like, hey, we can't file on this, inventor wants to, we will reassign, like a lot of universities will. But that rarely comes up. I mean, it's about one a year or every few years where we're doing that reassignment. I think part of it is because like we've reframed the discussion, where we're never saying no, we're saying not yet, or here's some resources to get you to the point where we can file a good patent application.
Vina, did you want to comment on that too?
Yeah, following up on what Bryce said, very similar situation to us. We will have many discussions with inventors in this case and really, really explain and get their input, and really, really try to help them in any situation. There are some unique situations where we will perhaps, like Bryce was saying, there's just no way we're going to be able to move forward with this patent because there's some patentability issues. If the inventor is really, really believing strongly in moving forward, we can sign a patent management agreement with them where they fund the cost of the patent moving forward, or there may be a gift fund or something else that they have in their department that they want to manage that cost for, and then we will do it. And those are not common; those are like once in a while. Usually I feel like the inventors eventually, after so many conversations, we were all on board. We all kind of reached the same conclusion. Sometimes it's just communication, and sort of really teaching the inventor what is, the right way forward. And then there's like also rare situation of returning rights, which just like Bryce said, it's for us, it's very rare as well, but that is the kind of last ditch resort.
Great. Steve, you had mentioned tools, like
Yeah.
such as global IP, et cetera. I'm curious in general, what tools you guys use to project future patent costs for your current portfolio, or are there other things that you do to just kind of help project what your costs are going to be, for the future? So, Bryce, maybe I'll start with you, but whoever has tools that they're using that they would recommend to the group.
Yeah, I don't think we're using an off-the-shelf product. I do know that our, great ops team, is modeling out projected total patent budget on a yearly basis. And, they're doing that based upon kind of like the framework that Steve talked about, based upon, patent applications that have been filed and where we typically incur costs based upon that timing. So that's kind of the level of analysis that we're doing on a case by case basis. We're getting specific projections from outside counsel.
Steve, any other tools that
Yeah.
you would recommend?
Um, I think one really great one is a LexisNexis product called Patent Advisor. And that one does a really good job of telling you for your own cases with the examiners you tend to get, how many office actions can you expect? And it's like a prepackaged report. If anybody on the call wants one, if you tell me, what your assignee name is and what art unit you want, I can print it for you. That's what it's for. But that's averages, which is only sort of helpful. I think if you have sort of fixed fees with your outside counsel and you can monitor which cases are likely to start entering active prosecution, that's still really the best way to be certain. I will also say, just circling back to one other topic we touched on earlier, which is, sort of the vanity or speculative filings. We do have some clients who on their fee sheet have, and they use various names for it, but it's like the, not as expensive application that's meant just to placate a faculty member. But I don't have any clients who have one that a fee item for you have started writing the application and you realize this is a goner and it should not be filed. And so it's actually been a difficult conversation to have with a lot of clients because it doesn't fit anywhere on the fee sheet for we did part of it, but we think discretion is the better part of valor, and let's stop drafting now because it's going to be terribly expensive. I don't know that you need to encourage that with a specific feed item, but again, part of the conversation with the outside counsel that we want you to tell us if something's a goner.
Okay, we have a number of other questions coming. Prior art searches. Who does the prior art searches at UW, Michigan, et cetera? Let's start with you, Bina.
Yeah, for prior art searches, we have two pathways. We have a vendor we use for most of our prior art searches, and then we also do them in-house. So depending on our patent manager's expertise, for example, we have physical sciences patent manager, protein design, biological sciences. If they can handle it, the prior art search themselves, depending on their expertise and their time, because it's just so high volume, we will do it in-house. We also send it out to a vendor. And then we recently, a couple of years ago, hired a in-house prior art searcher. She was an intern before, if that gives you a little bit context. And then she turned into this role as a patent specialist. And she does cut more customized prior art searches that are more customized for the inventor's whole portfolio.
Anyone else want to comment on prior art search?
Initially, it's our fellows. So we have a part-time fellows, full-time fellows program, that are doing like really high quality prior searches themselves. And then after that, it sort of depends, whether we go to outside counsel. What commonly happen is we'll identify a few kind of concerning pieces of prior art, and we'll go to outside counsel and say, hey, can you take a close look at these
Yeah.
to kind of follow up on the initial search.
I don't think we have any clients anymore that are asking us to actually run a whole prior art search.
Okay. All right. And then flat fees versus hourly. So there were a couple of questions about this. Steve, does Hush Blackwell do flat fee? Do they arrange those? Or is it typically an hourly fee type of quote? And then I'm going to ask the same question to Bryce and Vino.
It's entirely dictated by the client. I would say it's about 50-50. Some have, and they usually have their own fee sheets. Some tell us these are the fees we pay, and some ask for quotes.
Yeah. Bryce, flat fee or hourly?
Well, on the initial filing, we use not to exceed quote, and then after that, it's hourly.
Uh, Similar, we have our fee caps, and those are all
Yep.
flat fees for everything. Yeah, there'll be unique situations sometimes that come up, and we will just reach out to counsel and say, how much would you charge for this situation?
Okay. Do any of you ever allow your law firms to direct bill the exclusive licensees? Bryce, you want to start?
No, I don't think we do that at all.
Okay. Binu?
We do not that I know of.
Okay. And Steve, does Hush
We have,
Blackwell?
we have one client that
Yeah.
once in a while asks us to do it, but the sort of attorney ethics that go along with it um, are tangly, and it's probably not a do it every time type of thing because our bills will have, had a conversation with Acme University about this licensee. You don't want to send that to them. So it can be a pain in the neck to try and do that.
Yeah.
Sometimes it makes sense, but not always.
Great. Have you found a similar the time of application pendency to be similar between the US and the EP? And Steve, I'm just going to direct that to you.
Yeah, depends on the country. I think Europe can be a little bit faster. We're slowing down right now. Um, but yeah, pendency, I think overall is driven more by approach than country, just because there's so much variability. If you look at the USPTO's average pendency statistics, it's one number, but then you look among R1 institutions and it's all over the place.
Terrific. Great. I'm gonna There are a number of other questions left. I am going to encourage, because we are at the end of our time, I am going to encourage the people who wrote in those questions to reach out to each of you because they do have your email addresses to ask those particular questions. For those people who've actually cited their names, I'm actually going to send them to you afterwards so that you can answer them, and you can answer them directly. But I think that we are at our time now, and I do just want to, be mindful of the time that you have already given to this. This was fantastic. It was so interesting. Steve, I really appreciated your going through all the ways that you actually, cited, as an attorney, how actually you can make this a more cost-effective relationship. Vinu, going back to what both you and Steve talked about, was about communication. A lot of this is probably about communication and having better communication about the goals and what it is that you're trying to accomplish. Bryce, hearing about your team and what it is that you're doing to actually effectively make your decisions was fantastic. And obviously, you guys are terrific with your data, and that probably helps a lot with your decision making too on everything. So this was really informative. I hope everyone, I'm sure everyone actually got a lot of value out of this and things that they're going to implement in their own institutions. So thank you all so much for being here today, prepping all the materials, and I'm sure you're going to get a number of follow-up questions as well from everyone. So are there any last comments you have before we sign off? Should have asked that. No? All right, terrific. Thank you all so much. We will follow up with those of you who we didn't get to your questions. Thank you everyone for attending this today. Hopefully you got a ton of value out of it. And again, Steve, Bryce, and Vinu, thank you so much for your time today.